Hi all, it is indeed of great pleasure that I'm addressing this conference today. Apologies for not being physically there with you, however we had some local commitments that I had to attend to. Today, presentation is going to be on the verification of beneficial ownership information at registry level. We have prepared this presentation for you. All companies registered in Malta should be registered with the Registrar of Companies, and basic and beneficial ownership information are made available to the public by means of the portal. There is the link of our portal. In addition to that portal, we have also a fully populated register of beneficial owners information of all legal entities, including not only companies but also foundations and associations. Today I'm going to focus more about companies. The legislative framework, we have transposed the 4th and 5th EU AML directive, specifically Article 30 of the mentioned directive, and we have made reference to the FATF best practices on beneficial ownership for legal persons that was issued in October 2019. Needless to say, we referred to other resources such as the report that the World Bank has issued. In our framework of the beneficial ownership information, we have used the FATF suggestive approach, that is the multi-pronged approach. In brief, the multi-pronged approach, although I'm sure that many of you are familiar with this approach, is that you have verification of BO information at various stages in the legal system. The registry approach, that is having the BO information available in a centralized register, and that register is available for inspection. The second approach is the company approach, that is the information on beneficial owners is available at company level, that is the directors of the company and other officers are aware of who the beneficial owners of that particular company are. In addition to that, there is the third approach. The FATF refers to this approach as the existing information approach, and this relates to information available at other entities such as banks and other subject persons, including government competent authorities, where during their course of due diligence they are requesting BO information to verify who the owners of a particular structure are. And in Malta, we have indeed adopted this approach in order to ensure that the information is correct on beneficial owners. Needless to say, we had to face various challenges, one of them being that a company registry always played a passive role in the legal system. I'm sure that you share the same views as Malta. And therefore, once we had included new amendments to the law, and once we gave additional powers to the Register of Companies in relation to inspections, etc., that I'm going to go into later on during this presentation, the registry started getting a more proactive approach in investigating information. Also, we had lack of knowledge on AML CFT. Being a business registry, we were more concerned about the business and the objects of a particular company and not as such the AML CFT issues. We had also lack of sanction powers, which we had to legislate on. And also the beneficial ownership information was not a requirement for a company structure to provide to the Register of Companies, and therefore we have to legislate on that as well. These were some challenges that we faced as a jurisdiction while we were trying to transpose the Register of Beneficial Owners. It is important that everyone in a jurisdiction is on board. The importance of the key stakeholders. The key stakeholders are other competent authorities that are in possession of BO information, and also subject persons, including the general public. Subject persons like company service providers that are dealing with these structures on a daily basis, tax advisors that are creating these structures for providing the relevant tax advice, and also lawyers, accountants that are dealing with these corporate structures and that they can help in the verification of beneficial ownership information. The importance, I feel that the importance is twofold in relation to the responsibilities. That is, the importance of risk understanding who your client is and with whom you are dealing in order to be able to assess what type of risk that pose to a particular jurisdiction, and if we're seeing it from the MBR's perspective, the risk imposed on the Maltese jurisdiction and the entity itself. The importance of effectiveness of supervision on law enforcement. This is indeed very important. You cannot just have the law and you are not following that law by enforcement and immediate supervision of those provisions of the law. The BO definition in Malta, we adopt the same definition as that established by the EU, that is, having more than 25% plus one ownership interest, having at least 25% or more of the voting rights of a company, control via other means, and if these two tests fails, then a company needs to provide us with who the senior managing officials of that particular company are. The most challenging part is the control via other means part, because this in itself can be any type of control in a particular company. Control by other means indeed refers to situations where a natural person who does not hold more than 25% of the shares or voting rights, that is the first two tests that I mentioned, are not adhered to, or ownership interest of that particular entity, however, still exercises a significant control on influence over that particular entity. There is few reference in the EU directive of what control via other means can be, and one reference that can be found is in recital 13, whereby it is stated that control via other means include the criteria of control used for the purposes of preparing consolidated financial statements, such as through shareholders' agreement, the exercise of dominant influence, or the power to appoint senior management officials. And so the director is cross-referring us to the accountancy directive, specifically on that part in relation to consolidated accounts. However, from experience, now we've been with the Register of Beneficial Owners for the past 4 years, we can say that this is not just control via other means. Control via other means can be beyond this. Even just a power of attorney can make that a natural person also a beneficial owner. We have some exemptions under the regulations of the Register of Beneficial Owners, and these are when a company is itself listed. The exemption was provided and accepted by the EU because when you have a listed company, this listed company has obligations and strict obligations to disclose all the information to the general public. Therefore, the beneficial owners, if any, of a listed company are already visible in various sources for public inspection. We have also another exemption, and this is particular to Malta, because we have an exemption that the registered shareholder is a natural person. Therefore, whenever in a corporate structure you don't have any body corporates acting as shareholder, then we have an exemption, so that company is not obliged to disclose its beneficial owners. And this is because the beneficial owners are indeed already available to the Malta Business Registry. I have to point out that a natural person in Malta cannot be acting on behalf of someone else. If someone would like to provide that particular service, that is holding shares on behalf of someone else, that activity is a licensable activity and needs authorization from the Malta Financial Services Authority. If someone is caught having an activity that is a licensable activity, then there is also criminal sanction. And therefore, this is why we have obtained this exemption as well. One needs also to point out that our portal is fully accessible to the public, and the shareholders, even in these cases, when there is natural persons registered as shareholders, you will indeed find them together with the residential address and identification document number as well. So we're quite transparent on that as well. The population of the register of beneficial owners was indeed a challenge. We had around 50,000 companies, and we had to include new sanction powers on the register of companies in order to ensure that the information of existing company is being disclosed with the registry of companies. And one of them, and it was, I must say, an effective means, was the strike of procedure. We gave a deadline to all companies to disclose their beneficial owners, and if they didn't adhere to that particular deadline, we've started the striking off procedure. We didn't stop the strike of procedure unless the BO information was submitted. And in fact, we now have some cases that are being appealed in court because we have proceeded with the strike off. The court will not give that particular company the ability to be restored on the register unless the BO information is indeed disclosed. We also had to include administrative penalties, which for the Maltese jurisdictions were considered quite high for those companies that failed to provide us with BO information. We do not just receive BO information, but we verify that information. First of all beneficial owners, together with directors and shareholders, are screened against KYC databases. We have 2 KYC databases in place, and these individuals are all screened in order to check various variables. For example, whether we are dealing with a PEP, whether there has been a disqualification order from other jurisdiction, whether that individual is sanctioned, whether there are any freezing orders, enforce any adverse media. We screen all individuals of all companies that are being incorporated, and also existing companies that are in the process of changing their shareholders, for example, or beneficial owners. Any changes will trigger the screening procedure. We have asked also, and we made it a legal obligation, that every beneficial owner needs to provide us with his or her identification document. That identification document needs to be certified by a warranted professional, and that identification document needs to be state issued, therefore a passport or an identity card. This in order to confirm the existing of that particular natural person. And this is the actual veracity of the BO part, because here we are confirming that at least that natural person is indeed in existence. Changes to the beneficial ownership information needs to be reported within 14 days from the change. So if a company changes its beneficial owner, there is a legal obligation that the new beneficial owner is disclosed to the MBR within 14 days. Failure to do that, penalties will be triggered. Also, in addition to that, we are requiring that an annual confirmation is also provided in order to confirm that the data is up to date at least every year. So every year the company is requested to go through the information and then check whether that information is still correct. As a registry, we conduct on-site inspections, and this in order to satisfy the second part of the BO verification, that is the interpretive part. That is, we cannot just look at the statute and say, yes, that person has, for example, 25% plus 1, etc. When there is control via their means, you need to actually go at the registered office of the company and check whether there is indeed someone having control over that particular company. Because we are now conducting on-site inspections on companies, we have been given also the supervisory role in terms of the Malta's AML-CFT laws. Physical inspections are carried out at the registered office of the company, and this is done on a risk-based approach, and in fact we have put in place a risk assessment whereby we have identified those companies that pose the highest risk for Malta, and also with reporting of discrepancy. We made a legal obligation that anyone that thinks that a BO is not correctly disclosed with the MBR can file a discrepancy as well with the MBR, and then we go for an on-site inspections. Various documents are cited, such as the shareholders' resolutions and shareholders' agreements, power of attorneys, pledge agreements, etc. These are documents that we vet when we go for an on-site inspection. Reporting of discrepancy, I said it is a legal obligation for competent authorities and subject persons, therefore they are legally obliged to report discrepancies. In addition to that, the general public are also given a tool, and I'm showing the tool that we use, whereby whenever from the general public they have access to the BO information, you will have this sort of BO feedback tool, and the general public is asked to say whether he or she agrees with the BO information or whether he or she disagrees with that information. If the set phase is clicked upon, then that would trigger an on-site inspection from the MBR side as well. I've thought of doing some case studies in order to explain in practical how all this works. This is when you have a Maltese company owned 99.9% by an individual and only 0.1% by a body corporate. In that case, the exemption doesn't feature, and the beneficial owner will still need to be disclosed. In this second scenario, there is a corporate structure which is quite common in Malta, having a family business, having the children having 20% each. There's a company as well, and there's the father having only 1% of the shares, and however he is in possession of all the voting rights. That makes the father the beneficial owner of this particular company. In this case, this is an interesting case whereby one of the shareholders is the shares are held jointly by two individuals. You cannot say that Mr. C and Mr. D has 15% each, therefore no one is a beneficial owner. When in Malta, the law provides that when you are holding shares together, then you cannot say that one is the BO and the other not, but you have to disclose them both. This was our part in relation to beneficial owners and disclosures. If you have any queries, feel free to contact me on the email address that is showing there, and I would be very glad to help you out in any queries that you might have. Thanks a lot.
Hello, Dr. Geraldine. We're having a little trouble hearing you. Try again.
Hi, is this fine?
Yeah, very fine. Thank you.
Great. So great. It was indeed my pleasure to be addressing this prestigious conference today, and apologies once again for not being there physically with you. As a Maltese jurisdiction for this conference, we chose to focus on the verification of beneficial owners and information at registry level. Knowing that the concept of having a BO register is relatively new amongst several jurisdictions, and as a country we've ensured to make great strides in the to provide up-to-date information and peace of mind when it comes to the business scenario. During the presentation, as you've seen, we have delved into our approach, as well as I've wanted to share with you our FATF experience from the perspective of transparency, from which we have strengthened the existing framework, and we've learned a lot, and I wanted to share this positive experience, so to speak, as a jurisdiction with you all. I look forward and hope that our presentation is useful for you in your day-to-day operations, and I wish you a great day ahead and fruitful conference.
Thank you. Thank you, Dr. Geraldine.
Thank you.
Okay, thank you again. I'm glad she got to join us, at least virtually. We will now have a short